This week, the Supreme Court upheld a Rajasthan High Court ruling that made banks accountable under RERA if proceedings are initiated against the bank by homeowners of the project. Now, to give you a little context, banks give loans to real estate developers and the project is mortgaged to the bank. Now, when the developer sells a real estate project to home buyers flat by flat, home buyers in turn take a home loan from a bank. A home buyer cannot get ownership of his or her flat unless he or she repays the loan in full. What happens if the project is incomplete and the builder runs out of money? The bank can choose to auction the project to a new builder or even an equity fund who can complete the project. This is called a liquidation process. In all of this, suppose the home buyer does not want to wait out for the finishing of the delayed project but wants his refund with interest, he simply gets stuck. The bank claims that it has the first charge or right over selling the land and the project and recovering its loan. Now, this Supreme Court ruling that we are going to be discussing today has changed that. Avikshit Moral, partner at Indus Law, joins me to help us understand how. Avikshit, are we to understand now that if the home buyer has filed a claim of refund under RERA and RERA has ordered the builder to refund the money, the bank clearly cannot take the company to liquidation anymore?
So, Manisha, not exactly in those words, but if I place it with the context of the order of Rajasthan High Court and Supreme Court, what they have said that a bank or a financial institution will be now treated as a promoter. So effectively, you are stepping into the shoes of the original developer. So whatever claim that you had against the developer, let's say by way of an order of refund of your money and interest, would then go on and be binding on the banking institution as well. So as and when the process of liquidation happens, those monies and outstandings will have to be factored as payables to homeowners.
Okay. Do we have enough clarity then on how the courts will get banks, financial institutions to fall in line and execute the court orders? How can the courts really ensure compliance? I mean, it's a big thing that now banks are going to be treated as promoters of the project and it's a big win for home buyers. But how do you ensure compliance?
So, see, again, coming back to my original point, earlier there was this lacuna where banks were taking the view that, look, I'm not amenable to the jurisdiction of RERA. But now you actually can approach RERA and with multiple, case laws that we have in front of us, especially from Supreme Court, where they have time and again reiterated that the interest of home buyers are to be kept, supreme. And given that fact and the directions of the Supreme Court, I think RERA will be able to move much faster and, implement these kind of orders, in a scenario of liquidation if it happens.
But Avikshit, so many of RERA orders themselves are flouted by developers and even those are not adhered to or honored. So now we have a larger problem of RERA trying to get banks to fall into line. Do you think it's going to happen?
So I'll tell you something, Manisha, this is not the end of this issue. There will be more judgments that will come up because this time around Supreme Court has not got into the procedural aspects of things. They have actually clarified the larger legal issue of SARFAESI versus RERA and how to treat home buyers and things like that. But having worked with financial institutions and being a RBI guided institutions, I don't think that the situation will be similar as compared to a developer.
So when it comes to the procedural issues, what are the 3 things or 4 things that you now hope to hear from either the court or for, maybe RERA to wake up and then institutionalize to protect the home buyer?
So, Manisha, the issue is, while it's very complicated and may take a lot of time to explain the issue, but the fact is that right now there are 2 avenues that we have. It can either be RERA who can take over a project in the event of a default under RERA. And you also have a situation where a financial institution can take over a project in case there is a default under the financial documents. Now, you, or at least I as a home buyer, would want that there is sync between both these processes.
Right.
There's no reason why RERA or SARFAESI or a DRT court should have different views. And if we can come up with a single solution for completion of the project, because effectively that is what everyone wants.
Correct.
If the project is completed, home buyers are happy, financial institutions are able to recover the money. So that's what we are looking at.
All right, Avikshit, thank you very much. It's an important ruling, according to me, for home buyers, and we can only hope that courts continue to help close the gaps which have put home buyers literally at the receiving end of everything when it comes to a project delay. Thank you so much.
Thank you.
Well, from all of us, it's a goodbye, and I'll see you same time next week.